There has been much discussion about the impact of a no-deal Brexit on commercial transactions. But what will it mean for commercial litigation given the prevalent use of English law and English courts in cross-border commercial contracts? Let's first consider governing law. The position here remains largely unchanged and relatively straightforward. The current instruments which address choice of law for contractual and non-contractual matters in the UK and across the EU are the Rome I and Rome II regulations. Both these regulations have been brought into domestic law by the UK government. This means that whether or not there is a deal in relation to Brexit, the UK courts will continue to apply Rome I and Rome II when deciding questions of governing law. And courts in EU member states will also continue to give effect to the parties' choice of English law in contracts. So if English law was the correct choice for your contract before Brexit, that will likely remain the case even after Brexit. The position is less straightforward on matters of jurisdiction and enforceability of judgments. The existing rules on these issues are largely set out in two EU instruments, the Brussels Recast Regulation and the Lugano Convention. Both these instruments operate on the principle of reciprocity, and that reciprocity will come to an end on the 31st of December when the transition period concludes. So come the 1st of January 2021, what certainty do parties have that their choice of English courts will be respected in the EU, or that an English court judgment will be readily enforceable in EU member states? As a starting point, it is helpful to remember that there is a run-off period wherein certain EU instruments, such as the recast regulation, will continue to apply to cases that have been commenced prior to the conclusion of the transition period. Going forward on matters of jurisdiction, the 2005 Hague Convention on the Choice of Court may be of some assistance to parties. The EU is already a member of the Hague Convention, and the UK has now independently acceded to it. The Hague Choice of Court Convention will provide parties with some certainty that courts in the UK and in the EU will respect their choice of court to determine disputes. But the Hague scope is limited. It applies only if the parties have agreed an exclusive jurisdiction clause in favor of a country that has signed up to the convention. It remains unclear if it will apply to non-exclusive jurisdiction clauses or asymmetrical jurisdiction clauses. Similarly, there is a question mark about whether it will apply in the UK only to jurisdiction agreements concluded on or after the 1st of January 2021. A more straightforward resolution on matters of jurisdiction and enforceability would be if the UK were to accede to the Lugano Convention in its own right. This is because the Lugano Convention is materially similar to the Brussels Recast Regulation, and therefore accession to the Lugano would provide commercial parties with a lot more certainty. The good news here is that the UK has formally applied to accede to the Lugano Convention post-Brexit, and it has already received statements of support from countries such as Iceland, Norway, and Switzerland. However, and crucially, its accession to the Lugano Convention requires the consent of the EU, and that consent has not been forthcoming to date. If the UK does not accede to the Lugano Convention, then on matters of jurisdiction, the parties will either be reliant on the Hague Convention, assuming it applies, or they will have to rely on the domestic private international rules of the UK and of each EU member state. Likewise, on matters of enforceability of judgments, in a no-deal Brexit scenario, the parties will be reliant on each EU country's own national rules to decide whether or not an English court judgment will be enforceable and what the process of that enforceability will be. So here we are with just over a month to go until exit day, and uncertainties abound on matters of jurisdiction and enforcement of judgments. We will have to wait and see whether further comfort is provided to commercial parties on these issues, either by the EU consenting to UK's accession to the Lugano Convention, or the EU and the UK reaching some other deal before exit day.